Hello everyone, welcome to our talk. I'm Mang Cai, PhD, JD, attorney at law at Nonimmigrant Law Group. My topic for this talk is immigration intention. What do you need to know? Okay, sometimes you may have been asked, do you have immigration intention? If I do this or do that, will that constitute immigration intention? Will that affect my visa, my status in the US? Will that cause me any trouble if I renew my status in the US or if I apply new visa abroad? So let's talk about this. Well, if you are watching this video, probably you do not have US green card right now. Well, maybe you are holding visa in the US. And most likely, the visa is called a non-immigrant visa. That is just a technicality. There's also another category called immigrant visa. For example, before you receive your green card, if you have almost finished all the process and you're outside of the US, you will be issued a so-called immigrant visa, which you can use to enter the US and to receive your green card. Well, other than that, most of the visas are called non-immigrant visa. That includes the work visas, H-1B, also L-1, L-1A, L-1B, and O-1A, O-1B, etc. Well, that also includes other, student visa, F-1, visiting scholars visa, J-1, and other visitors visa, B-1, B-2, etc. Okay, those are all called non-immigrant visa, but some of them allows immigration intentions, or they are called dual purpose, while some others do not allow. Okay, so what will you do in order to have immigration intention? Well, formally, if you just tell somebody, I want to apply green card, I'm thinking about it. No, that does not constitute immigration intention. So, if you formally file an immigration petition like I-140 or I-485, that will constitute immigration intention. So if you file like an NIW or EB1, self-petition I-140, that is a step of immigration intention. And if you are doing that anyways, filing I-485 does not change the immigration intention by itself. So when time is suitable, you can consider also file I-485, adjustment of status. And what if you getting green card through employer-sponsored PERM application? The simple fact of filing PERM, that by itself does not constitute immigration intention. Only when PERM is approved and you file the subsequent I-140 to the USCIS, will that be considered as immigration intention. Another important fact is, there's principal applicant and there are family members. So, for example, if you file I-140, in the EB1, NIW, or other categories, that by itself is not the immigration intention for your children or for your husband or your wife. Okay, I-140 is for individual. It's only your own immigration intention. It's not your family members' immigration intention. And consequently, it will not affect your family members' visa status or their visa application. And your parents, of course, it's the same. It won't affect their visa application. And then there are differences among different visa categories. If you are holding, for example, H-1B or O-1 or L-1 visas, you can have immigration intention. For example, you file I-140 and then you leave the US and file new visa application abroad. Okay, that should be okay. Or you apply to extend your visa status inside the US after filing the immigration petition. That is also okay. You should be able to successfully extend your H-1B or O-1 or L-1 visa status. What if you are F-1 student? After you file the immigration petition, if the visa stamp on your passport is still valid, you should still be able to use this visa, to leave the US and come back using this same still valid visa without problem. And the same for J1. Of course, for J1, there's also a J1 waiver issue, which we discussed separately. If you have additional question about that, you can contact us. And for B visa holder, it's supposedly the same. For example, if you hold a B visa and it's valid for 10 years, if you file immigration petition, whether it's approved or not, you should still be able to use the valid B visa to travel internationally, including leaving the US and coming back. What if you need to apply new visa? Well, that will be tricky. For example, when you file a new visa application, you will need to fill a form called DS-160-160. When you file this form, there is a question asking, have you ever filed immigration petition? Okay. If you are holding work visa like H-1B, O-1, L-1, it's okay. Whether you answer yes or no based on the fact, it's fine. But if you are holding like a F1 student visa or J1 visa or B visa, and you answer yes, there's a risk that your new visa application may be denied. Okay? But it's not automatic. We do have clients who still received the new B visa after the immigration petition. So it's case by case. But in general, after you file the immigration petition, it will be better to avoid applying new student visa or visiting scholars visa abroad. You can wait until, for example, you receive a work visa like H-1B or O-1, or wait until you receive advanced parole. We have separate videos for those. So take home message, okay, immigration intention is after you file formal immigration petition, or maybe someone files such kind of petition for you in family-based immigration case. When you're holding certain work visas, it's okay to have immigration intention and still get a new visa. And your own immigration intention is not contagious. It does not affect the visa status or visa application of your family members. Okay, that's all I want to say about this immigration intention. If you need additional information, you can contact us. Thank you.